I want to tell all of you how much I admire you for being here. I went through divorce many years before Trey started The Good Divorce, and I wish I had had this. Every time I hear Trey and Molly and now Angela, I think I wish I had had that information. And I admire you because you're here, and I think you're here because you want information that you don't even know that you need. And divorce is very emotional for all the reasons already discussed, but it's business. If you do have a special needs child of any age and you are going through divorce, you must be aware of some things. I've found I work a lot with family law attorneys, many really good and really expensive family law attorneys, and they're expensive because they're good, know nothing about special needs. They know nothing about government benefits, how to protect medical insurance possibilities for your children. They know nothing about all the things that you live with and have to consider and the additional difficulties that you have. And when you're coming up with your divorce settlement, you need to have certain things in mind and to make sure that you're not only protecting yourself and your child's needs, but that you're always maintaining your child's eligibility for government benefits. And I'm going to get into more detail about that. These are things that you have to discuss in mediation. These are things that have to come up in your final settlement. You want to make sure that you're covered adequately when you go through the divorce in the first place. Don't think, I can't handle it anymore, I just need to get out of this, I just need to end it, I'm so pressured, and let me just sign it and I can come back later. No. Put your business head on and handle things now while you're going through the divorce. I am a probate attorney, and probate law includes guardianship and mental health law. Those are both part of my practice, a big part of my practice. And a big focus of my practice is long-term special needs planning. And there are certain legal issues that families with special needs children of any age must think about. Will your child, when your child turns 18, need a guardianship, or are the less restrictive alternatives appropriate for your child? What kind of estate planning do you need to do? We're talking about children that will probably be dependent or mostly dependent for the rest of their lives. And obtaining medical insurance for that child is always a key. I see some people shaking heads because you know what I'm talking about. If you're going through a divorce, the Texas Family Code allows for what's called indefinite child support for an adult child with disabilities. It's a different child support guideline than for a minor child. The Family Code separates it out, and then there's additional considerations, which I'll get to, but you have to know how to plan for that, once again, to maintain your child's eligibility for government benefits. There's a big distinction in all areas, legally and as far as government benefits go, between a minor child, that's someone under the age of 18, and an adult child, one that's over the age of 18. So until the 18th birthday, the parents are the natural guardians of the children. And that means that you make all decisions. Anything that happens to your child in school, the school better call you. You go to the doctor, the dentist, psychiatrist, a psychologist, you sign all the consent forms. You're the guardian. When your child becomes 18 by law, he's emancipated, and it happens on the 18th birthday, and that means that he's supposed to be his own decision maker. If you have a child that has difficulty making decisions because of the disabilities, just can't process the information, doesn't know how to ask appropriate questions, doesn't know how to make decisions that are best in his best interest, then you need to look at the possibility of guardianship or doing less restrictive planning, which is your powers of attorney. I always ask my clients basic questions. For me, I'm a very practical person, which may be why I'm drawn to this area of law, but it's practical. Does your child take medications? If your child, for what? Behavior problems, seizure disorder, psychotropic meds, whatever it is. If your child goes to the doctor, can your child discuss, once he's 18 or she's 18, over the age of 18, can he discuss these matters with the doctor? If the doctor wants to change the medication, can your child have a cogent conversation about it? If not, if you need to help them, you need to figure out some way to have ongoing legal authority to help your child. Same with medical and especially with psychiatric decisions. School and day programs. If your child is in special education, then he's entitled to special education under federal law and state law until the 21st or 22nd birthday, depending on the date of birth. Can your child advocate for himself at school? Can your child sit on the ARD, the planning committee, for what programs the child will be involved in, which classes he'll be enrolled in, which therapies he might be eligible for, occupational, speech, whatever. Financial concerns. Can your child manage a bank account? Does your child understand it? If you give your child $5, I've had clients tell me I gave him $5 and he ran into the food place to get, while I was filling up the car with gas, he ran in and he got a Coke, a bottled Coke, and came out and he had no change. And I said, where's the change? And he said, the guy took my money, because he doesn't understand. He doesn't understand even basics about money. Then those are things that you need to look at, and you may need to go for full guardianship for the child. And especially in social situations. And it's really difficult, and those of you with children with disabilities know this, sometimes the higher functioning kids are the most vulnerable, but that's a whole nother discussion. They know that they're different, they're lonely, they want friends, and they're vulnerable. If that pertains to your child, you may need to look at legal guardianship. And legal guardianship, only a judge with probate jurisdiction can appoint a guardian. When someone over the age of 18 goes under guardianship, his constitutional rights are taken from him. So they're given to you, the guardian, to protect, just like when he's a minor child. So it's a very serious legal proceeding. There's a whole process to it. And you don't want to just take the child's rights away unless you really need to protect the child. It can be done at any time. It doesn't have to be done on the 18th birthday. Sometimes somebody called me yesterday. Her son was in a car wreck when he was 24. He's 41 now. And when he was about 30, they finally realized that they had to get guardianship. They had no choice. He had a closed head injury. If your child can manage those things, even on a rudimentary level, then you may not want to take his rights away, and you want to foster as much independence as possible, and you can have him sign powers of attorney. It's an agreement between two people. I sign it and say, in the event of an emergency, then I appoint you to make medical decisions on my behalf. There's a medical power of attorney, the HIPAA release, that's consented disclosure of medical records. There's the statutory durable power of attorney, which is for financial and business decisions. I like to customize them for my high-functioning special needs kids. I put additional language in there of what specific powers the parent can have to deal with agencies and so forth, and deal with the Office of Disabilities at a local college, things like that if the kid's in school. The limitations on a power of attorney is they're easily revoked, and they can be declined by the third party that you present it to. So I've had people call me, the child is medically frail, and every time we go to the doctor and she has to have blood drawn and she starts screaming, "You can't take my blood," I said, even if you do a power of attorney, as soon as she says no, it's no, and it's revoked. It doesn't have to be in writing, so we looked at guardianship. There's another really important consideration for families with special needs children. If your child has a disability, and due to the disability, he will not be able to support himself through work, then he may be eligible for government benefits. There are different government benefits. They're administered by the Social Security Administration. You know, when you retire, unless you're a teacher or a firefighter or a policeman that has their own benefits programs, retirement programs, we're going to get some sort of Social Security retirement package. Anyway, I'm talking about government benefits, not through work, through the government. So we've got Social Security retirement, and that's based on the amount of taxes that we have paid into the system over the course of our working life. There's a Social Security death benefit. Once again, the amount is if a parent dies and leaves minor children. That's also based on the amount of taxes that a person paid into the system. And if we became disabled, there's Social Security SSDI, Social Security Disability Insurance. That's based on the amount of taxes that we've paid. What if you have a child that can't work because of the disability and has never paid taxes? Then he may be eligible for SSI, Supplemental Security Income. And with supplemental security income automatically comes Medicaid. This is key to people for disabilities. So your child has never been able to pay taxes. He may be eligible for SSI if, and this is key if you're going through a divorce or a modification of a divorce. There's two parts to qualifying for government benefits. One is you have to meet the medical need and prove why you can't work. And the other part is finances, because the government's policy is, we'll provide you with disability insurance. All the Western countries do it, and in my opinion, governments should do it. These are our citizens with disabilities. We should help them. We'll help you on condition you're indigent. And indigent is defined by the federal government as under I think it's $93. It just went up January 1st of 2021. $793 a month. If you have more than that, you may not be able to, you may not qualify for the benefits. And if you have more than, and remember these numbers because they're key, if you have more than 2,000 in combined assets, you don't qualify. The government's policy is spend down the money, and then we will provide benefits for you. Where is this important? If you have a child with disabilities that onset in childhood, and you're working with a really good family law attorney that's going to get you the indefinite child support, which is allowed under the Texas Family Code, if you get that, let's say you're going to get $1,000 a month in child support for your child, because your child is over the age of 18, the Social Security Administration considers that money your child's income. It's payable to you as the custodial parent. You can say the child has some mental disability and can't even count, let alone manage the money or handle a bank account. It's his money by Social Security regulations, and she or he will be disqualified from getting benefits. At the same time, the government has a policy that says you can get that child support and your child can get the full benefits on condition that the child support is payable to a child support special needs trust. And sometimes I use the word trust, we use the word trust, and people get turned off, like, I'm not gonna have that much money, I don't live in River Oaks, that doesn't pertain to me. No, a trust is a document, a legal document. I'll explain what a special needs trust is. But you as the custodial parent will still get the money, but it's payable to you as the trustee of the trust, and you set it up as a working checking account in your bank. But you have to have this document, Social Security has to approve it, you have to show that the Child Support Special Needs Trust was ordered, the creation of it was ordered in your divorce decree or in the modification of your divorce decree, and that a judge ordered it, and then Social Security needs to see the trust document. So I want to talk a minute about special needs trusts because there's 3 different types, and they're essential for planning in general, and if you're going through a divorce and you're going to mediation, I want you to at least have some basic knowledge about it, and be sure to talk to your divorce attorney. Don't expect divorce attorneys to know about this. This is not family law. This is government benefits. This is disability law. This is guardianship law. And you need to work with a family law attorney who will know to get assistance from someone that specializes in this area. If your family law attorney goes, we're not going to worry about that now. Well, let's get the property settlement in place, and then we'll worry about it. I would say you might want to confer with someone else. I would say you should confer with someone else, because once again, you have a child who will be dependent or partially dependent for life, and you're making decisions now that will affect you next year, 5 years from now, 10 years from now, 20 years from now. And you need to work with a financial planner like Molly, who's going to help you set up for your child, and then you need the legal documents. It all ties together. So there's different kinds of special needs trust. There's 3 kinds specifically. And once again, this is all regulated by the Social Security Administration. That's where our special needs trust laws come from. So there's the third-party trust, and I use this in my practice because I have so many special needs families. I use this when I'm doing estate planning, wills. And I tell the families, the third-party trust is one that's set up with your money or the grandparents' money, and the money is payable directly to the trust. The trust is kind of like a business entity. The trust owns the money. It's for the sole benefit of your child. But the trust owns the money, so your child never has money, because if you remember when I said earlier, to qualify for government benefits, your child has to have less than $2,000 in combined assets. So your child doesn't own the money, the trust owns the money. You get its own federal tax ID, it's not your child's Social Security number. This is essential in estate planning. Where is it essential in a divorce in divorce negotiations. And I've had family law attorneys, or I've had people call me, even my own clients that maybe we did the guardianship years ago, now the family's divorcing. We want to agree that we're going to take, I'm just giving you a round number. We want to agree that we're going to take $100,000 in the property settlement. We both agree. And we want to set it up into a trust for our child. I go, great, that's a third-party trust. What's the advantage of setting it into a third-party trust? Because the money is coming directly from you as the parents to the trust for the benefit of this child. When you have a third-party trust, properly drafted, when you have a third-party trust, then you name the remainder beneficiaries. So the trust has to stay in place for your child with disabilities life, and then on his death, it can go to your other kids. It can go to your nieces and nephews. It can go to a charity of your choice, to your church, or to the SPCA, wherever you want it to go. It's your money, and you direct where it goes. So that might come up. It doesn't come up in all divorce negotiations, but some divorcing couples do agree to set aside money for the child with disability, however old the child is. In contrast, there's the first-party trust. And what's the first-party trust? The first-party trust means the money belonged to your child in the first place. So it's a direct inheritance. It's proceeds from a lawsuit settlement. A lot of people are disabled, and a medical malpractice case happened and the child ended up disabled, or somebody gifts the child money, or there was a custodial. I have parents all the time contact me. Well, my parents set up an UGMA account, an UTMA account, some sort of custodial account. I had a family call me the other day. I've got an investment account with more than $100,000 for my daughter who's very, very disabled. We need to apply for benefits. I said, well, we have to do something with that account first, and we're going to put that into a first-party trust. A first-party trust means that the property was the asset was your child's in the first place. Child support for an adult child with disabilities is characterized by the Social Security Administration. Remember, that's where you get your benefits, from the Social Security Administration. That is characterized as the child's money. That has to go into a first-party trust. A first-party trust means, once again, the money was your child's in the first place. The government's policy is, okay, you have some money, which on the one hand disqualifies you from getting benefits, because our policy, the government's policy, is spend it down till you're indigent, and then you can apply for benefits. However, I don't even want to say however or but, it's kind of like at the same time, we, the government, have this policy, we'll let you keep that money on condition you structure it in this thing called a first-party special needs trust, to give you a pot of money to give you some quality of life. It can pay for care provider services, for a vacation, for therapies, for entertainment, computers, iPads, extra, new bedroom furniture, just about anything that your child needs, a cell phone, books, transportation, to give your child some quality of life. But now here comes the condition. That was your child's money in the first place. We didn't force them to spend it down to get them on benefits. But on your child's death, and once again, the trust has to be in place for your child's life, the money has to be reimbursed, has to reimburse Medicaid for any money that Medicaid spent on your child in the course of his life. Okay? Okay, so that's what it is. And I have people say, I don't want the government to get money. That's a whole nother discussion. But the government's allowing your child to have the benefits and to have this pot of money. If you want indefinite child support, this is what's key in your divorce planning or modification of your divorce decree planning. It's key. You need a properly drafted first-party trust. You need to be, if you're the custodial parent, you need to be named as the trustee. The trust has to be referred to in the divorce decree, and your family law attorney needs to confer with an attorney that works in this area, somebody like me or somebody else. It's a very narrow area of law, but your divorce attorney should get somebody for you. There's some really good people in this major metropolitan area. And you need the trust document. It all has to go to Social Security. And the benefit is your child can have the medical insurance, which is Medicaid. You can have the government benefits, which is your safety net. The Medicaid is your the safety net. And you can have this pot of money to have some quality of life and to take pressure off of you, to help with your living expenses. There's some limitations on what you can spend it on, but it's very limited. Let me just give you some final points here. There are family law considerations. First of all, if you have a minor child, means under the age of 18, and 18 is the 18th birthday, that's the marker, then you're in family law. You're in family court, and you're governed by the Texas Family Code. If your child is over the age of 18 and you need guardianship, you're going to be in probate court. If your child is over the age of 18, remember Social Security views him as an adult by law, and that child support is his money. If you are going through divorce and your child is not under guardianship yet, but you think you may need to do that, make sure that you discuss with your family law attorney and get it out in mediation. Work this stuff out in mediation. Who will serve as guardian, or will you serve as co-guardians? Because divorced parents are allowed, but you better get along. Who's going to pay for the guardianship? Work it out in your mediated settlement agreement that you're not going to fight over the guardianship. I've had so many clients contact me, they're reliving their divorce in probate court over the guardianship. Don't do that. Work it out in advance. If part of your family law, if part of your property settlement will be to set aside some money for the child, work with your family law attorney and get the third-party trust, no payback provision to Medicaid. And one thing I didn't say about Medicaid, let me get this out here because it's essential. Medicaid is not only comprehensive medical insurance. Medicaid pays for programs when your child's done with special education. Medicaid pays for a lot of housing. You may say, my child will always live with me. My child's with me now. Fine, but what about 20 years from now? When you're gone, what about 30 years, 40 years from now? When you're gone, will you expect your other kids to take their brother in with them? And work this stuff out in mediation, work this stuff out in family law while you're going through your divorce, and get a good plan. Thank you so much, Trey, for this opportunity to address Guide to Good Divorce.